everyone, it's Aprilia and welcome back to my channel. Today we're going to tell you about the federal fee state law in maritime cases. Pacific Maritime Magazine. It is often said there should be an uniformity in the law governing maritime cases no matter where they are tried. Article 3, Section 2 of the United States Constitution gives judicial power to the federal court to hear maritime cases. Federal statutory law allows certain types of maritime cases also to be tried in state courts, which supposedly are to follow federal maritime law, not state law, when the cases are decided. However, legal issues arising in maritime cases often are decided differently depending on whether the case is tried in federal or state court and whether federal or state law is applied. This video addresses four examples of the many maritime issues that have not been resolved consistently by the federal and state court. It appears some courts have become entrenched in their approaches, making it doubtful through a uniformity will ever be achieved. Overtime wages for seamen. The Federal Fair Labor Standard Act, FLSA, 29 U.S.C. Section 201 at SEC, first enacted in 1938, applies to, among others, employees who are engaged in an interstate commerce or in the production of goods in commerce. The FLSA addresses the right of employees to overtime pay when they work more than 8 hours in one day. The FLSA also exempts certain types of employees from the overtime pay requirement. Among the types of exempt employees are seamen, 29 U.S.C. Section 213b, number 6. The labor laws in some states, for example Washington, are consistent with federal law and provide an express statutory exemption from overtime for seamen. The labor statutes in other states, for example California, don't provide a statutory exemption from overtime for seamen. A collective bargaining agreement with the seamen's unions can override the federal and state overtime requirements. However, for the non-union maritime employer, the lack of uniformity can be problematic. Equally problematic can be the contradictory result in suits for overtime in state and federal courts. In Coil v. Jack Tanner Towing COINC 242 v. sub 2G 555 as Section T number 3 2002, seamen who worked on tugboat and the Mississippi and Illinois rivers sued their employer for overtime pay. The seamen worked primarily in Illinois water transport grain that had originated outside Illinois. The district court held they were exempt from overtime under the FLSA, which preempted state labor laws. The district court further held states may not apply their respective laws if those laws would interfere with the proper harmony and uniformity of existing admiralty law. Under the similar fact, a California state appellate court reached the opposite conclusion, holding state labor law preempted federal law and awarding overtime to seamen. Carmen v. Marine Express INC 2009 VWL 2625873 Call City of Apt 209 involved a tugboat operator who transported goods and personnel originating outside of California to ocean-going vessels docked or incurred in San Francisco Bay. He sought overtime pay for hours worked in excess of 8 per day. The California Court of Appeal reversed the trial court holding California overtime law applied and preempted federal statutory law because Carmen was a California resident and worked in interstate commerce in California waters. The Court of Appeal also imposed a monetary penalty on the employer for having paid Carmen in accordance with federal maritime law. And an assumption of the race doctrine. As a defense in a maritime case, defendants often allege the plaintiff's action should be buried because the plaintiff assumed the risk of injury or property damage when engaging in the activity giving rise the injury or property damage. In maritime cases, the federal courts have rejected the assumption of risk defense and instead use a comparative fault analysis. Under a comparative fault analysis, a party's recovery is reduced in proportion to his share of fault in causing the injury or property damage. Some states, such as Oregon, have statutorily abolished the assumption of risk doctrine. Other states, such as Washington and California, recognize the primary assumption of the risk doctrine as a potential bar to recovery depending on the circumstances. In Manning v. Gordon Act 153 v. Sub 1187 and D. Cole in 1994, a yacht owner sued another yacht owner in federal court for property damage suffered when their yacht collided as they rounded a course mark in a race. The defendant yacht owner asserted the assumption of risk doctrine as a defense. He argued that when the plaintiff entered the race, he knew his yacht would encounter high-speed maneuvers and be in close proximity to other yachts, and accordingly assumed the risk of damage to his yacht. The federal court struck the defense as invalid under the general maritime law of the United States. In reaching its conclusion, the federal court in Manning considered a California state court decision reaching the opposite result, that is, holding assumption of the risk was a valid defense in an action for personal injuries sustained during a yacht race. So that's all for today. I will continue the next explanation in the next video. So don't forget to subscribe this channel and don't forget to like, comment this video. See you in the next video and